United States attorneys, Preet Bharara, the U.S. Attorney for the Southern District of New York, and Neil McBride, the U.S. Attorney for the Eastern District of Virginia, are now in charge of prosecuting Khalid Sheikh Mohammed, the alleged and confessed mastermind of the 9/11 attacks, as well as 4 other 9/11 suspects. Needless to say, these 2 U.S. attorneys have a very important, very high-pressure job ahead of them, a job that will be made significantly more difficult by the fact that the policies of the previous administration allowed for the torture, the waterboarding of Khalid Sheikh Mohammed while he was in U.S. custody, 183 times over. In the 8-year fight over just how legal we want the fight against terrorism to be, the issue of torture, one of the recognized problems with torture, is that it's the kind of thing that a normal court might see as misconduct by the government, understandably. And would that kind of misconduct be grounds for throwing a whole criminal case out of court and freeing the defendant? When Attorney General Eric Holder announced plans to prosecute the 9/11 suspects during a press conference this morning, Michael Isikoff of Newsweek and MSNBC asked him how the government plans to deal with the inevitable efforts by the defense to bring the issue of torture into the courtroom.
Inevitably, defense lawyers are going to seek full disclosure about the circumstances of how these detainees were treated while they were in U.S. custody and want to get as much of that before the jury as they can. What is the department's position going to be on whether the defense will be entitled to know the full story of how these detainees were treated while they were in U.S. custody?
Well, I think the question, among the questions that have to be asked in that regard is relevance. How relevant were those statements? Will those statements be used? I don't know what the defense will try to do. It's hard for me to speculate at this point, so it's hard to know exactly what our response will be. But I'm quite confident on the basis of the evidence that we will be able to present, some of which, as I said, has not been even publicly discussed before, that we will be successful in our attempts to convict those men.
You are entitled to that evidence, entitled to know the full story of how they were treated.
Well, we'll see what motions they file, and we'll see what responses we make, and a judge will ultimately make that determination.
We'll see? We'll see? We'll see. Just as a person who has seen Perry Mason once or twice, I would say it is a safe bet that the defense will raise the issue of torture. They have to, don't they? What we don't know is how the government will respond to any such motions, how the judge will rule on them, and whether they will turn a terrorism trial into a referendum on the interrogation policies of George W. Bush. Joining us now is Michael Isikoff, Newsweek investigative correspondent and MSNBC contributor. He is reporting on the potential role of torture in the upcoming terror trial of Khalid Sheikh Mohammed and other 9/11 defendants tonight at Newsweek's new Declassified blog. Mike, thanks very much for coming on the show.
Great to be with you.
Watching the press or the announcement today, I have to say the Rachel Maddow Show staff was quite on fire about your question and quite mystified by the answer. Is the Attorney General saying essentially that there is enough evidence untainted by torture that they're pretty sure of a conviction anyway?
Yeah, Attorney General Holder was sort of glossing over what really was the most difficult part of the process that his team of prosecutors went through in preparing for this announcement. Because they know, Attorney General said, well, we'll have to wait and see. Believe me, they gamed this quite thoroughly, and they know all the motions that defense lawyers are going to raise on this, and they were very concerned from the outset that this trial could be derailed by allegations of torture and other abusive and the abusive treatment interrogation techniques. So they worked really, really hard to construct a case that was untainted by any evidence that was gleaned from the fruit of the poisonous tree, those interrogation techniques. So much so that they even are ruling out the use of confessions that some of these defendants made to an FBI clean team that the Bush administration set up to interrogate the detainees when they came back to Guantanamo, transferred out of CIA custody in the fall of 2006. The whole purpose of that clean team was to try to elicit confessions untainted by torture. But what the Obama people concluded was that those FBI agents already knew what these guys had said after they had been waterboarded and subjected to abusive treatment techniques, and that alone might be enough to taint the evidence. So they looked elsewhere to try to construct an airtight case independent of that, of those techniques.
You're reporting on that, them rejecting even the evidence obtained from the clean teams,
right,
implies an even deeper rejection of the Bush administration approach to these cases. I mean, not only are they trying this in a Title III, in an Article III court, in a normal court, but they're rejecting even what the Bush administration tried to do to clean up after its own evidentiary mess created by torture.
Exactly. They sort of concluded that there was no way to untangle any of that evidence from what was gleaned. Now, they do believe they have a very strong case, independent of, as one official said, all that torture stuff. They've got phone records, they've got computer files, they've got all sorts. They've got videos of, in at least one of the defendants taking credit for the 9/11 attack. In fact, there was an interview that Al Jazeera did with Khalid Sheikh Mohammed and Ramzi bin Oshib before they were captured, in which they praised and took credit for what they called the Holy Tuesday operation. So they're going to try to construct the case with all that evidence completely devoid of the CIA interrogations.
It sounds, if you're able to report tonight that they can describe all those different types of evidence to you, it sounds like they are very confident that they will get a conviction here. Are you detecting any worry either on Khalid Sheikh Mohammed or any of these other 4 defendants that they're worried that one of these guys might walk?
I don't think they're worried about a conviction. I don't think they think any jury in New York is ever going to vote to acquit any of these people. But I don't think they're quite as confident that they're going to be able to keep out all the evidence of CIA abusive interrogations. Even if it doesn't go directly to the evidence, there's pretrial proceedings about mental competence and whether or not they are fit to stand trial after undergoing all this abusive treatment. And then later on in the trial, assuming they are convicted, which I think they believe they will be, there's the death penalty phase. Right. Attorney General Holder said they're going to be seeking the death penalty, and in the death penalty phase of a federal trial, all sorts of mitigating factors can come in, including how they were treated while in U.S. government custody.
Right. In the penalty phase, what we're talking about there is a lot about the defendant, not a lot about what the defendant allegedly did to earn the conviction, because that's already settled at that point. Briefly, we're out of time, Mike, but let me just ask you quickly, are there any concerns that they're going to be able to find a jury in New York that can be considered a fair jury?
There'll be a very careful voir dire, but at the end of the day, I think everybody wants this. Everybody in the system wants this trial to take place, and a jury will be found.
Michael Isikoff, Newsweek investigative correspondent and MSNBC contributor, and a major contributor to what we now know about this decision. Thanks for your reporting and for joining us.
Thank you.